Good morning. I'm Paul Truster, program lawyer for continuing legal education, and on behalf of the Law Society of Upper Canada, I'd like to welcome you all to today's program, Workplace Sexual Harassment. Most importantly, I'd like to thank all today's speakers for their splendid efforts and for the time they've taken both in preparing their papers and in preparing their talks. Continuing legal education is a nonprofit arm of the Law Society, of course, and we're completely dependent on the invaluable contributions of our volunteer faculty. It's my pleasure now to introduce today's chair, John Page, who is a partner at Castles Brock and Blackwell and co-chair of that firm's labor and employment group with an active practice in that area. In addition, he's acted as counsel on leading constitutional cases which are described at somewhat greater length in the brief biography which you'll find near the front of the materials. Oh, you should also find, by the way, in the materials a number of more or less loose handouts which were simply printed too late to be included in the binder, but which I understand can be slotted in the appropriate spots. Our other co-chair, Sari Springer, also of Castles Brock, is not present today, but I understand John has a word about that. Please welcome John Page.
First of all, thank you all for coming, and much thanks to the participants who have done a lot of the work, and to the people at the Law Society who provide tremendous support for this type of endeavor. Very capable and professional, and I think if you look at the materials, you'll see the effort that's been put in by both the participants and the Law Society staff. You'll note from the promotional material and the program that there was supposed to be two co-chairs for this. One was my colleague at Castles Brock, Sari Springer, who has quite an active practice in this area, and in fact, if the truth were known, was really the person who did all the work at our end for the program. When we were setting the date, we were counting back from Sari's due date and said, well, we'll give it 2 weeks clearance. That ought to be plenty, so Sari can be here and participate and take the lead on some of the comments and speaking. I was sitting in my office, I guess about 8:15 on Monday morning, and the phone rang, and the message was, "It's Sari. I'm at Mount Sinai, and I'm in the early stages." The good news is that about 24 hours later, a little baby girl arrived, and parents and child are doing fine, but Sari can't be here. And anyways, she should have a special mention because she was very instrumental in putting the program together. Let me just make some brief comments about the problem that we're talking about today and how we've tried to structure the program to respond to the problem of workplace sexual harassment. One can get into a whole litany of statistics about how pervasive the problem is out in the workplace and society in general, and when we started putting together in-house seminars at Castles Brock for clients, we started reading the articles and looking at the studies, and I mean, frankly, I just found them to be quite amazing in terms of how pervasive and serious this problem was and out there in the workplace. Of particular surprise to me was that we act for some churches, and even an institution like that. There was surveys and studies indicating that 50% of the female individuals who worked in the church had reported from time to time some form of sexual harassment while working for the church, and needless to say, the statistics from other institutions went up from there. And of course, our own profession, the legal profession, has not been immune from the problem. The stats that are quoted at the beginning of Sari and I articles on the law firm indicate that again there's survey evidence of significant numbers of complaints and concerns expressed by female members of the law profession, and that's what we're going to talk about at the end. But let me tell you how we've tried to structure the program. We really aimed it more at the general practitioner and the human resources manager and people who kind of fall in there. It's not intended to be a minute dissection of the ongoing issues relating to sexual harassment in the workplace, but more of an overview to get people thinking about and dealing with and managing these problems. Mary Cornish is going to start off with an overview on developing legal issues and I think identify some of the areas where the law has gone and will be going in the very near future. Next, Susan Bisset is going to talk about developing and implementing an effective policy, which really is, I think, a theme that's really emerging in this area, which is implementing a policy to manage and control this workplace problem. We're then going to consider the actual dealing with a sexual harassment complaint before the Ontario Human Rights Commission, and fortunately have two people from the Commission coming to talk about how the Commission views and handles such complaints. And then we're going to move into what I think is an emerging but a difficult legal area, which is how the courts are going to respond to sexual harassments as cases are brought perhaps concurrently with complaints to the Commission and perhaps alone in the courts. And then Norm Grossman is going to deal with that emerging but difficult issue. The last two topics we're going to deal with, I guess, practical matters from an employer's perspective, what to do when a complaint arises. That's critical these days in light of some of the commentary in your materials. And then we're going to focus lastly in on responding to sexual harassment in the law firm. Denise Bellamy, who is a bencher very active in implementing the recent changes to the rules of professional conduct, is going to be here to speak about that. And I'm going to just make give you some thoughts and comments about how we've dealt with it at Castlesbrock and Blackwell. So again, it's an overview and try to get people thinking about and dealing with and managing this issue from both human resources and a legal perspective. Our first speaker is Mary Cornish, and the material in Mary's biography indeed really speaks for itself as to Mary's experience and commitment in this area. I think it's fair to say that Mary has been really on the cutting edge of many important legislative and case developments in this area and related areas relating to gender discrimination. And I consider this program fortunate to have Mary addressing it on the developing legal issues in this area, and ask Mary to take over.
Thank you, John. Okay. I'd like to start off by talking about the issue of, and you'll see I've used the term gender harassment, and in fact my computer went a little crazy and it changed in some of the sites sexual to gender, which in terms of a quote from the Supreme Court of Canada, where they didn't actually use gender, they used sexual. So I'll point that out a little bit later. But the reason I use gender is I think it's very important to understand that actually when you use the term sexual, people tend to think that actually then the harassment has to be something about either the sex act itself or that it has to be a comment that somehow has sex in it, when in fact what it is essentially is harassment against women because of their gender. And I think it's a very important distinction to make. And it was a distinction I actually tried to make in the jurisprudence starting in the late 70s and was reasonably unsuccessful with it for a long period of time. So it's actually quite interesting because John and I actually litigated a case called the Potopchik case, which was back in the early 80s, which was a federal politician and dealing with somebody in his office who'd made a complaint. But one of the issues was when people had maybe done issues of either a male would be making a person's workplace uncomfortable, might be sabotaging their work, might be doing a number of things, but if you were asked, well, did he talk about sex directly? It wouldn't always be that, right? And then you go, well, that's just kind of the normal things that happen in a workplace. Why do you think it's because you're a woman, right? And I think the recent cases of, and there's a one that's quoted in the material called Shaw and Lavac, which basically says that you have to look at whether or not it is happening to somebody because they are a woman. And if it is, the fact that in that case what was happening is that the man was actually making comments about the woman about her appearance, but how she was unattractive. And the employer was trying to argue, well, this wasn't really about sexual attraction, right? They were making comments about how she was unattractive, right? And so somehow this might have gotten you to escape from the definition of sexual harassment. And the analysis in the case talked about the fact that actually for this particular woman, the reason why she was targeted in the workplace was because this particular man was threatened by her competence, and the way in which he decided to deal with that and to undermine her was by making comments about her in a negative way about her, calling her a fat cow, and a number of comments like this that wouldn't fit into your kind of classic definition of an employer pursuing somebody in the workplace in order to have sex with them. But if you understand more gender relations, the analysis becomes a lot clearer, right? That you would understand that what was happening was that this man felt uncomfortable with somebody who he was supervising who appeared to be more competent than him in a whole host of areas, and the way in which he dealt with that was to constantly undermine her. And so I think that what's really useful when you're dealing and analyzing these cases is in fact to be familiar with some of the literature that deals with areas of how discrimination occurs between men and women. And I say that also because what has been understood, and only recently in relation to, for example, rape, that rape isn't a matter, and is certainly seen by psychologists as not a matter that this is kind of a sex born from a frustrated desire, but is really an act of aggression. And sex is really the weapon that's used, but that it's an act of aggression. And in the similar way that sexual harassment can be a way in which an aggressor seeks to make a colleague or a person they supervise uncomfortable in the workplace, and maybe a way in which they attempt to drive them out of the workplace. Now, this can be seen in some settings as quite differently. When it's seen very clearly in some non-traditional workplaces where women go into workplaces and take on jobs. I had a client who was a stationary engineer at Stelco, and there was a long history of harassment. This was the Benita Clark case that took place and was publicized for quite a long period of time. And there would be ways in which you would attempt to drive somebody out of the workplace. You know, you would, both the employer could be responsible for it and co-workers, either in terms of constantly having pornography around, making them, you know, she had to go to the washroom. They built a washroom, which meant that she had to kind of signal on her walkie-talkie in a huge kind of smelter whenever she wanted permission to go to the washroom. And all sorts of a series of and innumerable incidents of this kind, in which in the end it would drive people out of the workplace because they couldn't take this kind of level of attack all the time. So sometimes, or you'd get used condoms, you'd get all sorts of series of things left in your drawer, things like that. Now sometimes it can be that explicit, right, that people don't want you there. But in other settings, and I think people have to be more conscious of it, it may be played out in a more subtle framework. And certainly I've had clients who come to me who work in law firms in which sometimes it's quite explicit, but other times it isn't, and how they're made to feel uncomfortable within the law firm, either by colleagues who see them as a threat and make comments about them, make comments about how they're going to, you can't really rely on her because she's going to have a baby, or, I mean, there's a whole series of ways in which people can, in fact, discriminate and make a working woman's life difficult. So I think it's important when we start out to not narrow your view of what harassment is on the basis of gender. It's actually a very broad idea, and it's really anything, and the Supreme Court of Canada has made this quite clear in the Jansen case. It's what makes the workplace a situation where women are not able to achieve their equality within that workplace. And if a working condition doesn't promote the equality of women within that workplace, then it's a problem, and the employer has a liability to deal with it. The other issue that I'd asked you to consider too, because I think it's going to increasingly become an issue, is the intersection of race and gender in dealing with issues of discrimination. The case that we took forward to the Workers' Compensation Board that's referred to as the Colgate-Palmolive case in the materials, again dealt with a black woman factory worker. And in that particular case, we ended up meeing with a series of experts in dealing with racism who talked about that there was a particular form of sexism which was referred to as a racist sexism, that there are a way in which the particular stereotypes about women of color played out in a work situation. Now, in this particular work situation, this black woman factory worker was, she would have things nailed on her locker, which would be pictures of a black woman giving a blowjob to a white worker. And later on, she had another picture was put up on her locker, which was a black woman giving a hand job to a white worker in a lineup of 10 white workers behind her. And those were the kinds of things that were done to her and weren't done to the white women factory workers, right? And it was a particular way in which it was perceived that black women would be this kind of more likely to be available to these white men, and they had kind of visions of this. And in the end, she was on an assembly line in which there was a repeated, she had alleged a repeated sabotage of her work when it would come down the line, and then ultimately they sent down a carved penis. It was a soap line, and she ultimately had a nervous breakdown. And the issue that went to the Workers' Compensation Board was the denial of benefits because it wasn't an accident. And what is an accident for the purposes of workers' compensation and what they understood in terms of stress. And there was ultimately an adjudicative decision at the adjudicator's level, which in fact found that sexual harassment for the first time in Ontario was in fact a compensable matter. It went up to the appeals tribunal, and the day before the appeals tribunal was to deal with the issue, the employer withdrew the appeal. And but I highlight this because it's when you're looking at a situation, it may be very important to be informed about some of the literature which discusses the way in which either race and gender may intersect in order to understand what may be happening in your workplaces and how that affects it. And it also is important in terms of gender and disability. As if you speak to women within the disability movement, they see the way in which harassment happens to them as quite different as well. And that there are issues that they face in terms of their vulnerability that require special attention and knowledge and understanding in order to make sure that people are able to deal with it and supervisors understand it when people make complaints. So I think what you'll find is what it means is that dealing with these issues become more complicated, and that it's as well important that you have some understanding of literature and what experts say about it, and not necessarily just experts who deal with gender per se, but deal with some of the intersection of other issues. Now, the other argument that I think that I could talk about for a minute is in terms of the issue of employer liability. And I think that both the cases and the law are quite clear now in terms of employer liability. And I think as we talk later in the day, you'll be talking more about what's possible in terms of developing policies and whatever, many of which are directed to try to deal with the issues of employer liability. And I think that from looking at the cases itself, I think that that one of the things that still, I think the particular case that still was talking about it, if you look on page 7 of the materials, the Shaw and Levac case, which was a recent case of of a Board of Inquiry decision. Harassment is one of the the sections which is actually excluded from the overall liability of an employer of anything in relation to employment. But in this particular case, they found that the supervisor, in fact, as well, was a directing mind of the employer. And as a result, they used what they referred to as the kind of organic theory of liability. Certainly, the Supreme Court of Canada in the Robichaud case has made it clear that, and that was a sexual harassment case as well, and it was dealing with a supervisor, that it was going to be the liability of the employer to ensure that the workplace was safe. And perhaps if I can move from that issue of the safeness, because I think that if you look at this particularly from the perspective of women, dealing with this issue as a matter of safety is, I think, a very useful way of looking at it, and using a perspective of health. Because for many people, women in the workplace, certainly women who come to my office, the effects of the harassment can at times be quite severe. And so if employers see the whole notion of sexual harassment as being part of their work to make their workplaces safe for the women within their workplace, and to really understand that actually there's a lot that may be happening in their workplaces that is contributing to the ill health of their workers. And for that reason, certainly in the litigation that we did, we started to focus on health and safety, and we took a case called the Benita Clark case, which tried to use the Occupational Health and Safety Act and the obligations of an employer under the Occupational Health and Safety Act to try and deal with the issue of sexual harassment, which occurred in relation to the stationary engineer in Stelco. And there are a lot of quite serious obligations of employers under occupational health and safety legislation once you determine that what's at issue is something which relates to somebody's health. As well, of course, there are fairly strict laws with respect to the right of employees to refuse to work. And I think you may have heard recently there was press concerning the Toronto Hydro policy, which had talked about workers having the right to refuse to work if they believed their workplaces to be unsafe. And that whole concept that has now worked its way up into a policy is something that flowed from looking at using occupational health and safety legislation and the issue of harassment as one of the major health hazards in the workplace. So I think when you're looking at figuring out the liabilities for employers, it's important to look directly at the Occupational Health and Safety Act. We've also used it, for example, we acted for a nurse who was assaulted by a patient. And we filed a complaint and with the Occupational Health and Safety branch, who then said that the patient was not a thing machinery, I can't remember the other word in the Occupational Health and Safety Act, but you know, the employer, because it was a person, they weren't seeing it as the person as being a danger, right? Because usually you look at the machinery as being a danger. And we kept on saying, no, it fits within the wording within that, you know, there was kind of or other something, and they said, no, but we look at it like, you know, that it has to be that kind of a danger. And ultimately, though, we went through various stages of it, and they finally decided that the patient was a danger, and the patient was a danger in the workplace to this staff person who he had sexually assaulted, and that they had obligations because they knew that this patient was a danger, and that was partly the issue, right? They knew that the patient had been a danger to other workers, and that we therefore argued that they had obligations when they knew there was this hazard in the workplace to take steps to protect either other patients, potentially, or the staff who worked around this person to deal with this person as a hazard in that sense. But again, it takes a while, and it took us a while, to persuade people that this, in fact, was an appropriate interpretation of that piece of legislation and was as real a hazard in that health setting as might have been any piece of machinery. So that's another way in which you can try and look at the issues of occupational health and safety and look at the liabilities that there might be under those statutes. The other thing that I just wanted to address for a moment was the issue of the reasonable woman test. And the case that's referred to is actually one of the first sexual harassment cases that was litigated, which I was involved in, the Kikee and OPIU case, which is started in the late 70s. And that case first started to deal with the issue of who was the reasonable person when you were trying to identify whether something was, for example, likely to be unwelcome. And at that point, there was some understanding in that decision of that issue, but I remember that, I think John will probably remember that we still were having these arguments back in the Potopchik and McBain case about whether it was a reasonable man or a reasonable woman test. And the fact that for men and women, just as if you asked men and women what they felt about safety in downtown Toronto, you'd have very different versions of how people felt. If you ask people about how they feel about harassment in the workplace and what they think it is, you'd have very different views of it as well. And so this issue of perception is in fact quite important in terms of ultimately looking at the test of whether it should be kind of a reasonable woman test or a reasonable man test. And one of the I think quite useful decisions that's come down is the Lavallee decision, which was a decision of Madam Justice Wilson on actually quite a separate matter. She was dealing with the issue of whether or not a woman who was accused of murdering her husband, and whether or not a psychiatric evidence could be put in front of the jury with respect to why she might have done this, or whether it was in self-defense. And Madam Justice Wilson, in dealing with this, spoke about the battered spouse syndrome. And I think I've put in the cite from the decision at page 10. And part of the issue was what the jury would be able to understand. And she says, if it strains credulity to imagine what the ordinary man would do in the position of a battered spouse, it is probably because men do not typically find themselves in that situation. Some women do, however. The definition of what is reasonable must be adapted to circumstances which are by and large foreign to the world inhabited by the hypothetical reasonable man. And the expert had given evidence about how a battered spouse goes through a variety of stages of dealing with the battering, and which mean at times she may be quite submissive. That's partly what they were trying to deal with in this case, was why somebody who'd been submissive and hadn't reacted for a number of years all of a sudden shot this person, right? Why would this happen in this way? And the issue was whether you could bring expert evidence to explain to it. And essentially Madam Justice Wilson said is that the normal jury will operate on the basis of sexist stereotypes about what the battered spouse would do unless you provide them with some expert evidence about this problem, right? And which was quite an unusual. And then she talked about how the law had used to saying that it was okay to, in fact, or that the law had not been very good in the area of sexual assault before and had sanctioned sexual assault, and so you had to be very careful about it. But I think it gives you an idea that what you have to look at, I think, in the circumstances, and there was a dissent of a judgment that I put in from the mid-'80s from the US, which suggests using a reasonable victim perspective, which would allow you to consider what a reasonable person in the victim's circumstances would perceive as problematic. And but that if you just use the test or were led into being dealing with so much about whether or not what the man understood, since the man may live in a world in which he thinks that what he did was right, that may lead you in the wrong direction. So again, I think that it's important when dealing with this kind of test that you again keep following what, and I think people will probably keep putting forward expert evidence to try and give some understandings to the issues of how women in these circumstances perceive it. And I think also, I certainly noticed this from the perspective of having litigated these cases from the early 70s on, that now what I argued about in the late 70s, which people thought was crazy, now is starting to be more accepted, and people understand, oh yes, well that would be unacceptable conduct. Well, 10 years ago this wasn't considered to be unacceptable conduct, and women were being picky who were objecting to it. So I also think that we've moved a fair way in terms of people's general understanding about it in a workplace. But certainly from clients who continue to come to my office, there's a fairly long way to go. Okay. Now, I'm just going to, I think we're getting to the end of the time. John? For questions? Do you want to? Okay, all right. The other area, in terms of, if I could just go back and highlight a bit more, there's now been a workers' compensation appeal tribunal decision on gender and race harassment. The decision that I referred to is the Colgate-Palmolive one, and it was on page 11 of the materials. But it was an adjudicative decision and then was withdrawn prior to the actual tribunal decision. But I put in for you a recent tribunal decision which deals with the issue. And of course, once it's considered to be a compensable injury, it also then opens up the issue of rehabilitative benefits, pension, and a whole series of things, which are both liabilities that an employers need to be aware of and benefits that employees need to be aware of may in fact be there. The other issue is again, if I could go back. I've also noted that there are criminal code provisions, and that's at the bottom of page 3. And I'll just leave you with that one. And we've actually used this in one circumstance, depending upon what it is that is at issue. But they're criminal code provisions that deal with harassing phone calls and also watching and besetting. And at various points, even the harassing phone calls issue has certainly arisen in workplace things where either co-workers may start to call them or supervisors may start calling people all the time, and may in fact arrive at people's houses. And people may wish to look upon that as a possible way of attempting to deal with some of it, although I think generally people prefer to try and sort out dealing with it in a non-criminal code way. But I think that it's clear that there are other more serious consequences that can happen for people if they continue to harass in that way. Okay, I think that's all I have to say. And the site that I was referring to where the computer went crazy is the one at the bottom of page 1. It's the site from Jansen and Platty, where it says gender in the site from Mr. Justice Dixon. He said sexual.
Thank you. Mayor, any questions? Well, I have a question. I found one of the more interesting and perhaps difficult matters that's going to have to be dealt with in this area. Mary's comments about the various remedies that now appear to be available. I mean, one is presented with a victim, and there now appears to be several places one might go, including the commission, the workers' comp board, I guess a refusal to work, and again, Norm Grossman will speak about a potential civil remedy. Do you have any thoughts on what goes through your mind when you're deciding about that, or any views about what is the appropriate form in a practical sense?
Well, I guess there's two ways of looking at that. I've just recently chaired a task force into the reform of the Human Rights Code. And I think if the Human Rights Code were operating on a more expeditious basis, I think the Human Rights Code provisions, and certainly I've recommended a new way for trying to deal with it, which would get it going more quickly. I would prefer to use that kind of a remedy do it if in a non-organized setting. As well, there's recommendations about deeming harassment and discrimination provisions into collective agreements, so that's another way in which you might do it. And in the proposals that I've put forward, I've suggested that if you start in one route, for example, if you filed your sexual harassment complaint under a collective agreement, that if you then went through that route and were unsuccessful, and went, for example, to the Human Rights Commission after that, that at that point you would have to show that there had been some miscarriage in the original procedure, or that it didn't have all the remedial relief that the code would have in order for you to actually attempt to relitigate it somewhere else. Currently, I don't find the human rights provisions and that route to be a quick route. So while I wouldn't, I certainly wouldn't use that as the only route, although you may well say that you may file one, but I would normally proceed with it, or I may file one, but the problem is that unless realistically you can proceed very quickly, or the employer is really concerned you may proceed quickly, they may not be that upset that you filed it, right? Although some employers are more worried about that than others. Often I find in corresponding with people that certainly if there's a collective agreement, I normally go that route because I can control how quickly it proceeds. And civilly, I mean, I think at the moment with Badaria, although there's some ways around Badaria, and I'm sure Norm's going to be talking about them, there are not a lot of ways. And this is the Supreme Court of Canada decision that says that the Human Rights Code is a complete right, and that there is not a tort of discrimination. Now, I think a lot of us have been trying to think up other torts to try and deal with this, and I've spoken a bit about whether or not there's also a breach of fiduciary duty in a workplace. But the reality for most average people is launching a lawsuit is a complicated, costly matter, and not a lot of the people who come in my door are able to just launch civil lawsuits and start into discoveries. And I mean, you may threaten all of this, but the reality isn't that that's a very realistic way of pursuing it.
With respect to the standard of the reasonable woman,
Mm-hmm.
is it a rigid one, or does it shift depending on the racial, religious, or ethnic background of the person?
Well, there hasn't really been a decision which has gone through this to any extent at all. I think that the case that the cases have talked about trying to look at what the circumstances were in that particular workplace. Some of it talk about what the actual harasser knew as well. For example, you may have something that somebody else wouldn't consider to be offensive at all, or but the harasser knows this person thinks it's offensive, right? And that, I think, would be found to be harassing if you knew it was offensive and you did it, even though the person next to you wouldn't have been offended by it. And that's why I'm saying that, and that's more that you're using it as a way of trying to undermine or demean somebody because you know it's something that they wouldn't like. So in that sense, that's kind of in some ways the, it's not a let's put it this way, that wouldn't be a reasonable woman. You could say a reasonable woman wouldn't be offended by it, but he knew that that woman was. and did it again. But yeah, I think they will look at what the perceptions are of people, and cultural issues will come into it, because some people, again, have quite different views about what's appropriate or not appropriate.
You cited the case of a woman who was harassed on the basis of gender and competence,
Yep.
where a man in the workplace felt threatened and referred to her as a bad cow.
Right.
And you cite that as an example of gender harassment.
Mm-hmm.
As between two men in the workplace, where one is threatened by the competence of another,
Mm-hmm.
and refers to that person as a fat pig or whatever,
Mm-hmm.
that's not gender harassment. I have a difficulty in the case between a man and a woman, where it may be more an issue of competence that causes the threat, as opposed to an issue of gender.
Well, you can read the Sean Levac case. It's quite a long case talking about this harassment took place over a period of 10 years, and the adjudicator goes on at length trying to determine whether it was on the basis that she was a woman or not. They used other evidence that this person, this supervisor, made demeaning comments about women generally, about kind of why didn't they go back into where they were, where they'd been in the with their children, and why were they in the workplace, and a variety of things like this, which weren't comments which were directed at men within that workplace. So in any particular workplace, you're going to look at it and see whether or not this is something that is done to this person because of her gender, and something that wouldn't be done necessarily to a man. Now, there may be other reasons why something may happen as between men, right? But what you're dealing with here is whether or not it's happening to this woman because of her gender and because of the place within that workplace. Now, this particular supervisor said, no, he was saying all of these things as a method of improving this woman's performance. Well, and the adjudicator said, this is just ridiculous, right? I'm not going to believe that this man demeaned her for 10 years in order to improve her as a management tool to improve her performance. But I guess it does require an understanding of relations between men and women in a workplace. And the relations between men and women are different than between men and men. It may well be that men and men are also trying to undermine each other, right? I mean, I'm not saying that they're not doing that, but there are very particular ways in which women are undermined and men do it.
You can't look at every situation where a man is undermining a woman in the workplace and refer to that as gender harassment. You have to look at more than simply that, do you not?
Well, and this case looks at a series of things, yes.
When you give the background of the Shaw case, that makes it clear that they look beyond more than
Mm-hmm.
But it won't be every case of a man undermining a woman in the workplace that will be sexual or gender harassment. Does it go that far?
No, I mean, in the end, you have to show that the harassment is in relation to her gender. I mean, in any case, you're going to have to prove that. But as people more and more understand, what I'm trying to say is that as you more and more understand how the dynamics may occur in workplaces, you can more understand and put into a context things that happen and understand them in that context. But yes, you'll always be looking at a context of that workplace.
One more question. Thanks.
Is there a distinction in the case law between the word, I'm offended by your conduct, or I'm angered by your conduct? Because you could have the employer be a real jerk, but not be offensive in a gender sense. And yes, it's going to impact on your performance at work because perhaps you're under more pressure or stress. But if you're not affected in an emotional or physical sense, can you still classify that under gender harassment?
I would argue you don't necessarily have to have an impact in the sense of whether or not you are in fact stressed out in order for you to have to prove it, right? Those are really what your damages are. They're not the proof of whether the incident occurred or not, is what I would say. So yes, if there's something that's occurring to you because of your gender and either for whatever reason, and people also react differently to these things. And one of the things I think that and it's another way in which I think people have misunderstood stuff, is that women often act as kind of the emotional managers in these relationships, and they try and there was evidence in this Sean Levac case, that she would try and kind of, oh, well, don't worry, you know, she wouldn't respond in the way somebody else might tell the guy to fuck off or to whatever in the workplace, right? And that then gets them into other trouble. And I've had cases where the woman's then being disciplined because she said this to the supervisor, right? But people have different reactions to it, and often women may just try and ignore it, may try and do a variety of things that are later then perceived to be that she didn't find it offensive or she would have said something, right? And so I think that's why you're going to hear about how with policies, what you're supposed to do is try and get the actual people who are doing these things to stop them, so that the women don't have to spend their lives trying to figure out, and their work time, trying to figure out how to respond to these people, and then they're not doing their work while they're worrying about what the person's going to do next, right? So
I think for time reasons, we have to move to the next speaker. Perhaps you can, everyone who's speaking has some deep background in this, so maybe you can reserve your question or rephrase it, but if we continue on to questions, we won't get through our agenda. Mary, thank you very much. I think you've opened some interesting discussion in some rapidly developing areas. Thanks. Our next speaker is Suzanne Bisset, who brings to our program a wealth of experience in dealing with this issue in the very practical context of advising in labor and employment law issues. From the short biography, you can see that Susan has been quite active in an employment and labor practice with McCarthy's for some 12 years, and Susan's going to talk about the practical importance of developing and implementing a workplace policy to deal with this, and I suspect we'll make some comments about how the attitudes of employers in responding to this issue have rapidly developed over recent years. Anyways, I'll let Susan take it away.
Thank you, John. For 13 years of my practice, I've been saying to employers for whom I've acted over the years, you should have in place policies relating to human rights in the workplace, including sexual harassment. And it was not until really, in my experience, Anita Hill's allegations blasted into the media that suddenly clients who had deaf ears for the last 13 years were phoning saying, oh, should I be worried about sexual harassment in the workplace? Yes, you should be. Well, what can I do about it? And one of the very practical things that employers can do is implement a sexual harassment policy. Now, on a general note, some employers prefer not to just have a sexual harassment policy, but rather a general human rights policy dealing with all forms of prohibited discrimination in the workplace, including, of course, sexual harassment, sexual solicitation, reprisal for rejection of a sexual solicitation. And in my view, it is preferable to have a general human rights policy and not restrict it simply to sexual harassment, because then you're going to have one policy that you can use to deal with any form of discrimination complaint in the workplace. And you're not going to have a multiplicity of policies, one for sexual harassment, one for race, one for creed, and so on. One policy, you make it work for everything, and you generally educate your workplace accordingly. So in my view, while it's fine to have a sexual harassment policy, it makes a lot more practical sense to have a broader policy than that. So what happens? Employer calls you, says, I'm interested in having a sexual harassment policy. Is it a good idea? Why should I have one? Well, Mary has already indicated to you the developing case law in the area of sexual harassment. Obviously, employer liability is mounting in this area. That's one good reason to have it. For example, for federal jurisdiction employers, they are mandated to have one. Now, a lot of people don't realize that because most of us don't have a lot of federal jurisdiction clients. But if you're acting for a bank, an airline, interprovincial carrier, you must be aware of the fact that the Canada Labour Code says expressly, you shall have a sexual harassment policy. You shall consult with your employees before you implement a sexual harassment policy. And furthermore, here are certain mandatory provisions that must necessarily be included in your policy, A, B, C, D, E, and I'll come back to that in a moment. So, first question is, who's your client? Check out the jurisdiction. If it is a federal jurisdiction client, you must refer to the Canada Labour Code provisions dealing with sexual harassment policies. If you're dealing with a non-federal jurisdiction client, why have one? Obviously, the first good reason is deterrence, education, making the workplace safe for your employees. And on that point, let's raise consciousness out there. And having a policy in place is going to do no good if it's buried in a policy manual, molding away in some file drawer where all the policies are stuck and nothing's done with it. So to make it effective from a deterrence point of view, preventative medicine, consciousness raising, by all means get your client to have one, but make sure that you also discuss with your client how it's going to be brought to the employee's attention and ongoing education about the policy. So it's not molding away, not being observed at all, or being observed in the breach. Okay, we've moved on from prevention, deterrence, consciousness raising. Why else? You want this in place as a very practical means of avoiding human rights complaints. We all know that human rights complaints are very time-consuming, extremely costly, and give rise to unwarranted or unwanted publicity from an employer's perspective. Having an effective policy in place can avoid all of that. Not necessarily. There may still be complainants who do not feel satisfied with any redress that takes place pursuant to the policy and who still want to file a human rights complaint. But in my experience, you can minimize the number of complaints by having an effective policy in place that really deals with the issue. The third reason is employer liability. Having a policy in place gives rise to an argument by an employer, look, I have taken all reasonable steps to deal with this. And on that point, you should be aware of the fact that under the Canada Labour Code, again, dealing with federal jurisdiction employers, there is a due diligence defense available under the Canadian Human Rights Act. So having this kind of policy is an effective means of arguing this is due diligence. I have taken all reasonable steps to deal with this and to stamp it out and to make sure it doesn't occur. And having that policy can be an effective way of doing that. And lastly, having a policy provides a very practical way for employers to carry out an investigation of a complaint. You all have had the panic-stricken telephone call, I'm sure, from a client saying, just had a person walk into my office, not always a woman, can be a man alleging sexual harassment by his superior or another co-worker who happens to be a woman. Having a complaint come in, what do I do? What do I do? And this sort of panic. And if you have a policy in place that tells you how to go about dealing with this, you can minimize a lot of knee-jerk reactions, which can get a lot of employers into trouble. People running around like chickens with their heads cut off, not knowing how to effectively deal with a complaint. Having a policy, having a complaint procedure, having it spelled out can go a long way to wiping out those risks. Okay, so those are the reasons that I see from a practical perspective for an employer having a policy in place. I want to deal a little more in detail with federal jurisdiction employers and the provisions of the Canada Labour Code, because even if you're not acting for a bank or an interprovincial carrier and so on, the code provisions dealing with sexual harassment policies, which are outlined in my paper, I think are quite instructive from the perspective of what sorts of things should you include in a policy. Section 247.1 of the Canada Labour Code says that certain provisions are mandatory to have in a policy. And don't forget, as I mentioned at the outset, that a federal jurisdiction employer must have a sexual harassment policy brought about after consultation with its employees. A policy under the Canada Labour Code basically must contain 7 components, which are outlined in my paper. I'm not going to deal with them in any great detail other than to say that they must define what sexual harassment is in substantially the same way as the Canada Labour Code defines it, which is different than the definition under the Ontario Human Rights Code. Under the Canada Labour Code, sexual harassment is defined as any conduct, comment, gesture, or contact of a sexual nature, first of all. Now, in the Ontario Human Rights Code, as it currently is worded, it must be a course of vexatious comment or conduct. So unless it falls within sexual solicitation, a single gesture, comment, or contact would not constitute sexual harassment, which was always the argument when that definition was coming in. It basically condones the single incident. The Canada Labour Code definition is broader, and a single contact, comment, gesture is sexual harassment for purposes of the code. The definition then goes on to say it must be likely to cause offense or humiliation to an employee, or might on reasonable grounds be perceived as placing a condition of sexual nature on employment or on any opportunity for training or promotion. So when you're tailoring your sexual harassment policy, be cognizant that if you're acting for a federal jurisdiction employer, the definition that's got to go in your policy is the one that's in the code or substantially similar to it, which I suggest to you is broader than the one under the Ontario Human Rights Code. It also goes on in the code to say you must have a statement that every employee is entitled to be free of sexual harassment, that the employer is going to take reasonable efforts to deal with it, discipline, how complaints are to be dealt with, and so on. So I refer you to that section in the code as being a good starting point for the points that you should consider even in drafting a policy that will apply to a provincial jurisdiction employer. For provincial jurisdiction employers, what should you have in a policy? In my view, you should have a statement of purpose. Why are you having this policy? And I think the appropriate purpose from an employer's perspective is to provide a workplace that is safe and that is free of prohibited conduct that falls within the purview of not only sexual harassment, but discrimination on the basis of sex and sexual solicitation. A lot of employers seem to forget in drafting policies that sexual solicitation should specifically be mentioned. It is another form of prohibited conduct in the code, and it should get recognition in your policy. So you're not just simply stating we're going to provide a workplace free of sexual harassment, but free of discrimination on the basis of sex and free of illegal sexual solicitation. Again, going back to my earlier remarks, if an employer decides to have a general human rights policy, not centering on sexual harassment, then of course the purpose clause would have to be broader to encompass all prohibited forms of discrimination in the workplace, including discrimination on the basis of sex, illegal sexual solicitation, reprisal for having rejected a sexual solicitation or advance. Okay. So a statement of purpose. And in the purpose clause, I think it's important that an employer bring out the big stick and say that it will not tolerate this kind of conduct in the workplace. It's again a consciousness raising. It's to make employees aware that the employer means business, that whatever may have happened before and everybody turning a blind eye is not going to happen anymore. That this is viewed as serious misconduct and that appropriate steps will be taken by the employer to deal with it. And I think it's important that the big guns come out in the purpose clause to really bring employees' attention and focus it on what is a very serious workplace problem. Now, secondly, a policy should give some indication of what sexual harassment is. And I would suggest to you that a good starting point when you're dealing with a non-federal jurisdiction employer is citing the definition out of the Human Rights Code. But let's face it, that's not going to mean very much to the average employee who isn't trained in the law, who can't analyze a very legal definition out of a statute. I think it's a good idea to give some concrete examples of what sort of conduct could be illegal sexual harassment. And I've listed a few examples in my paper. I would suggest that citing legal definitions out of cases is not very instructive to the average employee. So try and bring it down to what an employee could perceive or be subjected to on a day-to-day basis in the workplace. Bring it home. Graffiti, sexist jokes, so on. Things that he or she can understand and put in the context of their day-to-day work environment. The next point that I think is very important to put in a policy is a section dealing with responsibility. Now, certainly, it is the responsibility of the employer to provide a safe workplace free of sexual harassment and solicitation. But it's also important, in my view, that employees also be reminded of their responsibility, because no policy is going to work dealing with this problematic area unless employees are also willing to, in effect, help management police it. If everyone is afraid to come forward, if everyone is going to turn a blind eye, it's very difficult to get complaints coming up through the system. And so if employees are told in the policy, you have a responsibility too to help us, assist us, work with us to make sure that we do have a workplace free of unwarranted sexual harassment. You have to help us. You have to bear some responsibility for bringing these matters forward. It's no longer good enough that when you observe conduct that is clearly sexual harassment, you can just turn a blind eye to it if no supervisor or no manager happens to be around. Let's have that kind of conduct coming forward and provide an effective mechanism in the policy for that to occur. Again, it's fine to put that in your policy, the responsibility section, but it's not going to work in practice unless employees really feel that the employer wants to know what's going on out there. So let's not have hollow words. I think it's fine to write this in a policy, but an employer must go further and educate the employees, have seminars, have training sessions where this whole issue is brought out, discussed, and employees are encouraged to come forward without fear of reprisal. I mean, let's face it, everybody's afraid of losing their job or afraid of reporting that Joe Schmo's harassing me because Joe Schmo is going to be giving me a promotion next week. The fear of workplace retaliation is very real. And unless you develop and foster an environment where employees are going to feel that they can come forward and should come forward, you're not going to have it working effectively in practice. The next thing that a policy must address is a complaint procedure. Now, much discussion ensues about whether or not a complaint must be in writing before it's dealt with. And my recommendation is no, absolutely not, not at the outset. You could deter a very credible complainant from coming forward with a complaint if he or she felt that it had to be reduced to writing, so formalistic right off the bat. I think it's important that dialogue get going. An employer can always, later on in the process, ask for a written statement, but to do so at the outset, I really believe is a great deterrent to complainants coming forward. So personally, I don't recommend that it be reduced in writing in the first instance. I think an employer has a duty to look into, investigate any complaint of alleged sexual harassment or sexual solicitation. And to require a complainant to reduce it to writing is, in my view, making it extremely difficult for someone to come forward. The next key issue is, to whom should the complaint be made? Now, you obviously have to tailor this very much to the employer you're dealing with, and that goes for the whole policy in question, but it really becomes key here. In a small family-run operation, it's obviously ridiculous to have the complaint being referred to a human resources department, which probably doesn't exist, right? It's also, in my view, absurd to have a complaint being addressed to the chief executive officer of the enterprise. Talk about a deterrent, that would certainly be it. It also doesn't make any sense to say you have to refer your complaint to your supervisor, because the supervisor could be the problem. So you should provide alternate complaint procedures. In most cases, you can say, please feel free to address your complaint to your supervisor or to X. And X should be an appropriate person. I would suggest not someone who is the chief executive of the enterprise. If there's a human resources person available, great, that's the person it should be. Alternatively, it could be another supervisor. But it's important that the alternate is available so that there is a mechanism whereby they will feel free to go to somebody. And on that point, I would highly recommend that whoever is going to be the conduit or the recipient of complaints get some training. Okay? It's very important that the person who is receiving the complaint know what to do with it. And simply being a supervisor without anything else is not sufficient in my view. I recently had a client who sent in a sexual harassment policy for my review, and they had drafted it to provide that any supervisor or manager becoming aware of a complaint would immediately investigate. And I had a vision of these supervisors or managers who knew nothing about the area, you know, running around doing all sorts of incredible things which could get the employer into hot water. So very important that appropriate training be given to the person receiving the complaint. And I highly recommend that that person be sent out to workshops and acquainted with the provisions of the code and given some very basic training in complaint investigation before he or she is seized with this responsibility. Investigation. An investigation procedure obviously has to be included in a policy. I personally do not recommend that incredibly detailed steps for an investigation be outlined. Why do I say that? Because I don't want management to be hamstrung with a procedural irregularity. I think management has to be free to conduct an investigation as it sees fit in a given case in light of the particular circumstances of the case. And I would not want an argument coming up later that the entire investigation was suspect or had run afoul because step number 1 was not followed precisely to the letter. I think it's important that a statement be made that management will promptly investigate, certainly. Training can be done on the management side as to how investigation should be carried out, but personally I am not in favor of having a detailed investigation procedure outlined in the policy statement itself. Remedial action. A policy should contain a provision saying that management will take appropriate remedial measures to deal with allegations of sexual harassment or sexual solicitation that are proved to be founded. That is very important. The message to employees that we are not going to put up with this and you're going to have to pay the consequences of conduct that runs afoul of the policy. I think it important not to say what remedial measures will be other than a general statement that appropriate remedial measures will be taken up to including dismissal. I like the word dismissal in there. It gives a very clear message that management is treating this seriously. But I don't think you should say this will be the response for the first offense, this will be the response for the second offense. Obviously, if it's serious, immediate dismissal may well be warranted for a first offense. The other thing that I find lacking in practice is that once remedial measures are taken, nobody tells the complainant or complainants. You know, so management investigates, finds, yes, violation here, and nobody tells the complainant that steps have been taken. So what's the complainant to think? Management's turning a blind eye. Nothing's happened. I filed a complaint. Nobody gets back to me. I'm going off to human rights, or I'm going to do something else very inventive like Mary has indicated. Tell the complainant what steps have been taken to deal with it. That message is important. And if a complainant isn't happy, then you can, as I will come to in a moment, have an appeal process built into the policy. Or at that point, the complainant may say, well, that's fine, I am going to human rights. But get back, let the message be communicated. Appeal process, a lot of debate centers around whether or not you should have one. And again, I think whether or not you do very much depends on the context of the workplace you're dealing with. For example, if you have an organized, unionized environment where you have had, in effect, for many years, a grievance procedure that follows various steps, it may make sense to have an appeal process very much like the last step in a grievance procedure. If you have an unorganized workplace, it's a family-run establishment, it may not make any sense whatsoever because whoever was in the know has already done the investigation. There's nobody else to appeal to. So you have to look at it in the context of the workplace. And whether or not you choose to have one will very much depend on the nature of the employer in question. Confidentiality. Extremely important that your policies say allegations and complaints of sexual harassment, sexual solicitation will be treated confidentially and will not be disclosed. But you can't stop there because you may have to disclose them. If you're going to properly investigate, other people may have to be told. So I recommend that you say they will be treated confidentially and they will not be disclosed except if necessary to carry out an appropriate investigation or to take appropriate remedial action. But very important that a complainant knows and is assured that this isn't going to be spread all around. It's also important from the alleged harasser's perspective if the complaint proves to be unfounded, which is the case in some circumstances. Again, important to have in your policy a no reprisal statement, that people coming forward with complaints will not have reprisal measures taken against them by management, by other employees, by the alleged harasser. Again, it's a comfort level that I think is very important if you want to have complaints coming forward and not being kept quiet. Notice of the policy, I alluded to this earlier. You can't have a policy that nobody knows about. Doesn't make any sense. So you have to, when advising a client, make sure that management is going to bring the policy, once it's formulated, to the attention of employees, including the management team within the operation. How can you do that? You can post a copy. You put it in a policy manual of which employees are given copies, and you review it with the employees. I personally favor having group seminars within the company at which all employees, mandatory attendance is required at those seminars, where an overview of the Human Rights Code is given, the policy is reviewed, questions invited from the participants, and that this is done on an ongoing basis. You can't just do it once. People change, employees come and go, management changes. It's important that it be done on a regular basis, and it's also important that your policy be updated on a regular basis to make sure that it's still current, that it still jives with the current state of the law. And those are all my comments, unless anybody has questions. Yes? Mm-hmm. I think you could do it in one policy as long as the policy contained a sexual harassment portion that jived with the provisions of the code. Okay? There's nothing in the code that says, you know, this has to be separate and apart from any other policy. As long as the mandatory provisions are in, you'd be okay to encompass it within a general policy. At the back, the gentleman in the back. Mm-hmm.
They have 18 drivers, some of whom are employees, some are not contract. The company is owned by Dora. Dora is the president and operations manager. Sal is the dispatcher who has the employees.
Mm-hmm.
And she's also the payments. And when Sal was out in the yard, in the habit of having the drivers in the pub, driving them by the truck, making other suggestions, remarks, and gestures. Now, who does this 250-pound gravel truck driver complain to about this little lady who's sexually assaulted? And she, within the framework of the sexual harassment policy. And that's not the very part that.
Did everyone hear the question? Okay. So I won't repeat it. First of all, on your facts, you would be required to have a policy because you've cited a case where there's interprovincial trucking. It would be required under the Canada Labour Code. There's no carve-out. There's no exception in the code for a small operation. Every federal jurisdiction employer must have a policy, including a complaint procedure, all right? So on your, in your facts, you'd have to have one. To whom does the complaint get filed? I would have to know more about the operation. Obviously, there has to be somebody else there to whom a complaint could be made. The mere fact that it's a small operation, in my view, doesn't mean that you don't have to have a policy in place, and it doesn't mean that you don't have to have a complaint procedure. Obviously, you got to work with your client. Question there? Mm-hmm.
I advise that federal government departments, when we do have a harassment policy in place, not a sexual harassment, but a harassment. One of the questions I canvassed my clients who were coming today, and one of the questions that Grossman had, they contract out to an investigator to investigate the complaint. They want to know what they should be looking for in an investigation so that they know that the investigation was done properly. Because when they contract out, it's out of their hands, they don't have any control over it. So I couldn't answer the questions, I have no experience with it, but have you any experience in what a proper investigation should be?
Okay, did everyone hear the question? This woman has a client who contracts out investigations under a general harassment policy and wondered what sort of investigation should take place so they know that they're getting their money's worth. In my experience, I don't have any client who contracts out investigations, probably because it's not generally cost effective. I would suggest that if someone were going to do that, you would obviously want to shop it around and see the sorts of procedures that they would have. They should have written procedures in place for conducting investigations. There's nothing magical in terms of A, B, C, D has to be done, because obviously the investigation has to vary with the facts of the particular case. What you may do in one case, you wouldn't do in another.
There was a particular question. They wanted to know, this is the second question actually, not with respect to contracting out, to inform the person against whom the complaint was made promptly or immediately. What does that mean? Because generally when they receive a complaint, they look at the complaint, they talk it over with the person who has made the complaint, and they refine or the complaints, put it in precise terms, clear terms. That takes a number of days. When the word immediately, what does that mean? Does that mean as soon as the complaint is received, or does it give the person who has received the complaint time to sort of make it more clear or talk it over?
Well, if your policy says immediately, I would think it would be, depending on the context, immediately upon the complaint being received. I wouldn't put that in a policy, quite frankly, from a practical perspective. I wouldn't say anything about required notification to the harasser. Certainly in the context of an investigation, a harasser will be advised at some point of the allegations against him or her, but you may not want to do that right away until you have started your investigation, for fear that the person will cover his or her tracks or attempt to take certain reprisal measures.
I apologize. We're going to have to, and it's great that there's lots of questions, but we're running about 20 minutes behind. Let's take our 10-minute break. Can you stay around? So we'll see if we can.
Yeah, I can see.
Okay, for a while. We may have to restructure things, and we might be able to take a few more questions to Susan. Let's just cut the break to 10 minutes and start again at 11:15. Thanks a lot.